of having with me Benita Collier, who is in-house at Urban One. And she's going to talk in just a second. Matter of fact, I'm going to let her talk for a long time. I'm going to do a quick rapid-fire Q&A, something a little bit different that we don't normally do with these panels. But I thought I would exercise personal prerogative, and since MTEMA gives me the discretion to mix things up a bit. Next slide, please. Oh, okay, all right. This is just our acknowledgement slide. It's just letting you know that the comments and opinions that I make, the comments and opinions that Benita Collier here makes, they are not on behalf of Urban One or on behalf of my firm. They make me put that in there anytime I speak, so I apologize for that. I'm sure you've heard that thousands of times. All right, so I was thinking earlier this week, as was Benita, about what are the top 10 IP-related issues in the media entertainment space? And I did several Google searches, and I'll say Google because we have Google here as a sponsor. My wife works for Microsoft, so anytime I'm in an audience with Microsoft, I say Bing. I did a Bing search, but today I'm going to say I did a Google search, and was having a hard time finding kind of a top 10. It wasn't that easy to find. So what I decided to do was just say, hey, these are the top 10 IP issues in the kind of media and entertainment space that I face as outside counsel, clients that I deal with that are in this space. And in a minute, I'll have Benita go into further detail from an in-house counsel perspective on the next slide. But on go back one, yeah. So just want to stay here just for a second. So from an outside counsel perspective, issues that I deal with, or my clients deal with, or they ask me for help with, if you are the brand owner, obviously trademark and advertising clearance is huge. You're trying to either clear a term that you want to use as a mark, or register it as a trademark, or the complete opposite. You just simply want to run the ad. You could care less about the trademark protection of it. You just want to know you're not infringing on anybody else's potential trademark. That is an ongoing issue. It overlaps with the internet and social media in some regard. Another major emphasis, obviously, is trademark enforcement and infringement. So you have actually found someone who is using your mark. And trademark infringement is obviously a huge issue, and we see that in this Fox's Empire case, which I'll talk about at the end. Copyright infringement, this particular seminar and institute has talked about this to death, I think, but it's nonetheless still an ongoing. I believe it's up on appeal right now in the Ninth Circuit. So that's a major one. Obviously, on the defense side, if you are accused of infringement, your typical go-to defense, right, is going to be fair use, possibly non-trademark or descriptive use. Yes, I did use what you call to be your mark or a confusedly similar variation of your mark, but I didn't use it that way. I used it in a descriptive sense. I used it in a non-trademark sense. I didn't try to register it. I didn't try to copyright it. It's not subject to protection in this context, most likely within the purview of the First Amendment. Same is true in the copyright context. You have fair use and transformative use. So those defenses, to me, under that kind of generally fall under the First Amendment, still major issue from an outside counsel perspective. Social media, I'll get a call every other week. Hey, such and such used my name, they used my likeness, without my permission, take it down. How much it cost? Can we call Facebook? Can you call Instagram? Social media is going to be around for a while, and it can continue to be a problem if, like I said, from an outside counsel perspective, when you're dealing with litigation. Same is true with the internet. DMCA takedown provisions. That's huge. I'll let Benita talk about this in a slide or two. Digital distribution, that is key. How can we push out products to mobile phones? Because more and more people are watching TV or listening to the radio on their phones. And Benita, just so you know, I have the TV One app, and I watch that. and I also have the News One app, and I listen to that, and so that digital distribution is major. That's not going anywhere. You see a lot of entertainment companies that try to renegotiate or revise their contracts once they're up, or when it's time to have amendments, because the language may not have, the language at the time may have only said radio, TV, film, or other digital media that existed, digital formats that only existed at that time. Nowadays, you're starting to see more broader language that says whether now or forever known in any kind of digital format, but that's not always the case in a lot of these contracts. And then obviously right of publicity, I'll touch on this case that I'm currently dealing with. Federal Trade Secrets Act, that has now been implemented, right? President Obama signed that right towards the end of his tenure. The trade secrets law has now been federalized. So unlike right of publicity, from a trade secret perspective, you can file suit in federal court now, and you can claim Federal Trade Secrets Act so that you can capture subject matter jurisdiction. You don't necessarily have to sue in the state court where that particular former employee that's ran off and stole something. And I'd cite the Bratz doll case. MGA Entertainment, they had owned, or still do I think, owns Bratz dolls. They got into a huge fight with Barbie dolls. That litigation was going on for quite some time. And then finally, breach of contract. That's, to me, always a major issue as well. Next slide, please. And then we'll go back to that in a little bit. All right, so now we are going to introduce Benita. And what I'm going to do is ask Benita a range of questions. I've got a list of 10, and we're going to take 1 minute for each one. And Benita, if you're going too slow, I've got to speed you up. But I want to get this all in, so it's important. But before I do that, it is important that we are introducing people the right way. So we have a clip that we would like to play, which will give us a more formal introduction, a sizzle, if you will, of Urban One. All right. Well, hello, Benita. Tell us who you are once again.
I'm Benita Collier. I am I mostly am on the radio side of things. Of course, as you saw from there is radio, there is television, and there is digital. And I am one of 4 attorneys on the radio side. I represent, mostly provide legal support for 5 of our radio markets, Atlanta, Indy, Philly, Dallas, and Houston. They're very active markets, and I find myself working with very creative people on a daily basis and dealing with the challenges that comes with working with those types of folks.
So you are IP attorney by trade?
Yes, I am a trademark attorney by trade. In this particular role, I handle all types of matters. I mostly counsel clients on different types of contracts, different types of promotions that they're trying to do. I help them to put events together. What I do just sort of runs the gamut of the issues that comes up in the different markets.
So what made you go into IP? And would you tell a law student who might be in the audience now to go into IP?
I would say go into IP. I started off in family law. I went to law school thinking I wanted to become a family law attorney, and I finished law school thinking I wanted to be a family law attorney, and I went back home to Mississippi, and I worked as a divorce attorney for a small firm, and found that that was just a bit much for me. I was dealing with an issue that for the people involved was probably the single most important thing going on in their lives, but for me it was a case, and I had other cases that I had to deal with, and sometimes people would want to, sit on the phone and talk about their frustration for hours, but, and I didn't have billable at the end of the day. I was on the phone talking to this person about their frustration. So at some point, it just wasn't for me, I didn't enjoy dealing with that same sort of adversarial issue every day. So I started to look around for other types of law that I was interested in because, as I said, I went to law school to be a family law attorney. And in looking, I stumbled on, really, it was copyright, the soft IP, and I thought that would be interesting to do because I would be able to work with creative people. Very naive of me, but and that's what I was interested in, working with creative people, helping them to protect their rights and that type of thing. So that's kind of how I got interested in IP.
So was there one, and you can't name them all, because I know there's plenty of them, but we just want one for today. Can you name one mentor that helped you kind of transition and navigate into IP and kind of allowed you to kind of blossom, if you will?
Well, the one mentor that I would mention, she didn't necessarily help me to navigate into IP, but she definitely helped me to be successful in the law firm setting. And that is Sandria Ridgely, and she's actually a current colleague of mine at Urban One. She knew the value in directing work to diverse attorneys in large, medium-sized law firms. And I met her at a NBA commercial law section conference one year. We interviewed with her, and another of my colleagues and I interviewed with her, and she liked us as associates, not partners, but just as associates. And she sent her work to our law firm. Of course, we worked with partners because we had to, but she was very invested in making sure that we were valued in the law firm setting. And I went to at least 2 other law firms after that as an associate, and she followed me to each of those law firms as an associate, not as a partner. And whenever I got to those firms, she talked to the partner who I would be working with and let them know what her expectations were, not just for the work, but as far as my success. So and she was also instrumental in sort of talk to me about coming to work for Urban One when I did. And she's been just a very valuable asset to my practice.
Is there anything, and you got to be honest now, because we're real talk, confidential setting here. We would like to shoot from the hip. Anything you miss about being outside counsel?
Yeah, I miss
Oh, come
as
on.
outside
Tell the
counsel.
truth.
Yeah, no, seriously.
You don't
as
miss those
outside
global hours?
As outside counsel, I was a step away from the client, just a step, and that sort of gave you a little bit more breathing room. Now,
Yeah.
I get phone calls all day long, emails, and they're expecting an answer when you answer the phone, within an hour or two, something. So I felt like as outside counsel, I was a little bit, I had maybe one contact with the client to deal with, or a couple, but they really are. And I'm glad they call me because, sometimes you have markets that don't call the attorney. I'm glad they call me. I'm glad we have that rapport, but it can be overwhelming.
So you've been with Urban One now for 2 years?
Almost 3.
Almost 3.
Yeah.
Tell us one thing that you actually do really like in your current role at Urban One.
Well, prior to now, I was only doing trademarks on a day-to-day basis. This position helps me to do just a wider range of things. My days don't look the same. And I like it. It's also a challenge, but I like doing different things on a daily basis.
Now, Benita, you have, tell us about how you go about processing your decision-making skill set. Because you said no day's the same, and you're getting calls or emails, and they want to answer immediately within the hour. So you're often having to make very quick, real-time, contemporaneous decisions because they're going to launch a product or
Yeah.
an app or an ad tomorrow. How do you deal with the time constraint? And talk to us about this gut reaction phrase that you like to to
Yeah.
use with me,
Yeah, sometimes I ask Jonathan, just give me your gut reaction.
which I hate. But I like you. I like working for you. Yeah, but I do it. Whatever you need me to do, I do it.
No, sometimes, different things are coming at you all day long. And sometimes it can be overwhelming. And sometimes I find myself overthinking. Like when I do that, okay, what does your gut say? It's because I've spent way too much time and I feel like I'm overthinking it. And it's just sort of my reset where I step back and say, okay, does this seem right? Okay, no, it doesn't seem right. Why doesn't it seem right? Okay, this is why. And then I sort of talk myself through the issue. But it's just my reset. And sometimes when I ask you, it's because I've just completely overthought it, and I know I have, and now I'm just trying to find somebody to just sort of to step back and just sort of give me their just objective
Right.
impression.
So for those of us who are outside counsel in the room, give us some advice. Tell us one thing that is a pet peeve you can't stand or you wish that we could do better.
Well, when I was outside counsel, I worked with partners who were very strict about, customer service, being responsive, following the directions of the client, and giving the sort of executive summary at the top of the email, and not sort of, giving clients a whole just pages of opinion and not having, having your conclusion at the bottom. So I think now that because that's the way I was trained. Now when I see something that's not like that, I'm like, I wish someone had told them to be upfront about their advice. Give advice. Don't just, go through analysis and leave it for me to basically provide my own conclusion. Give advice. If we've asked you for advice, give your advice. Give it up front. Answer the questions that are asked, and be responsive.
Okay, great. Can we go back to the top 10 slide, Miss, please? Thank you. So from an in-house counsel perspective, and you don't have to touch all of these, but at your discretion, which of these jumps out to you in terms of what you deal with?
On a regular basis?
Sure, yes.
Definitely trademark and clearance, a lot of copyright.
Why? Let me stop you. Why the trademark and advertising clearance?
Well, because a lot of they want to do different sort of promotions, and of course they want their promotions to stand out in the market, and they'd like to use whatever words they want to use in connection with their promotion. A lot of times they want to use the most recognizable thing, and sometimes the most recognizable thing is actually something that belongs to somebody else. And I have to, Super Bowl. Well, we're having a Super Bowl promotion. Okay, well, we can't use Super Bowl. So that type of thing, and sometimes they think they've come up with a mark that they want to use for something, and I think they've seen it before, but they kind of think maybe I won't find it, but I always find it because, that's my job, is to find, if there are any problems with different marks. So, yeah.
Okay, what else on the list?
Copyright. We do a lot of digital work, and at one point we really had to stress the fact that, all these images that are so easy to throw up on the website are protected, and we were that was something that we really had to teach people, because they felt like, oh, it's out there, it's on the internet, why not? And so once you get these takedown notices and that type of thing, and sort of training, they finally got the message. Rights of publicity. A lot of times we have rights of publicity. They want to use someone's picture on a market T-shirt or radio station T-shirt, or want to use up someone's picture on something else that is sort of commercially driven, and you just sort of have to talk them through these things. And of course, having that's where the good rapport comes in, because they're at least talking to you about it, rather than it rolling out and there being problems. They call me up. Hey, is this a problem? Yeah, it's a problem. It's the same problem that we had a few months ago. It's a problem. So I appreciate the fact that they do call. But yeah.
Okay. And what about digital distribution? I mean, Urban One owns through Radio One over 55 to 56 radio stations nationwide. But some people may not necessarily listen to the radio, but they still may want to hear the station or the program. So they're downloading the app or listening through. Other means.
There's streaming on the different radio station websites.
Okay.
That I don't really have any issues to come out of that. Most of the sort of digital that you're talking about is handled by the Interactive One team in New York, and so they handle a lot of the digital issues that come up.
Okay, great. All right, let's thank Benita for giving us. She answered at least 12 questions, I think. Next slide. Oh, obviously these are just quick facts about Urban One.
Kathy, what is he?
Oh, that's right. That's right. So what we thought we'd do now is kind of give a case illustration of some of what we're talking about. Obviously, there are a lot of different issues that are sporadic throughout this related concept between entertainment and media on the one end and advertising on the one end versus the legal aspects on the other. So one particular issue that comes up in this industry is obviously names associated with shows. Can I use this title? You go through the clearance process. Legal team says yes. TV show or the movie is released and get hit with a demand letter or a lawsuit or what have you. So one particular case that I've been following, I know some of the lawyers involved with it, has been 20th Century Fox. They sued, they actually filed a declaratory judgment for non-infringement against Empire Records. Now, if you're not paying attention very closely, you might think that all of those photographs, are kind of intermingled here. You got Empire on the left, and you got Empire on the right. So those are two distinctively different entities, though. Empire Distribution, Inc. is an actual record label that exists in California. It existed long before Fox's Empire TV show. The emblem that you see, or the logo that you see above the Empire, along with the word Empire, that is the trademark or the logo that the record label or the distribution label has used for quite some time. They did not, and I think this served to their detriment in this case, they did not have a federal registration for that logo or Empire. Had they had that, obviously I do think then you may kind of further attack Fox by maybe a suggestion that they had constructive notice, because if you look on the PTO electronic database record, you can see applications or registrations for particular marks that you may want to use. And that's what companies such as Benita's company that she is with at Urban One, that's what they do. They will search the PTO database. So this record label didn't have trademark registration for Empire, and not filed it. They had common law rights, but some of their artists have included either signed directly as artists or through partnerships. Kendrick Lamar, Grammy award-winning artist, as well as Fat Joe and Remy Ma, among others. Snoop Dogg as well. Next slide, please. So, on summary judgment, Fox's Empire won, basically, on the First Amendment defense, and more specifically under the transformative artistic relevancy doctrine that's also called the Rogers test. out of the Second Circuit. And so here in this case, you had Fox's Empire, a ruling that was favorable to them, and essentially the court, in applying the Rogers test, found there to be artistic relevancy, separate and independent from the use of the mark that could indeed cause a likelihood of confusion with Empire Distribution. And in fact, that was kind of the whole point of why Empire Distribution had sent a demand letter to Fox, because they were getting calls, they were getting misdirected inquiries, they were people were asking them about, hey, did you watch the show? They were finding some similarities with some of the artists. Anyone who does follow Fox's Empire knows that Terrence Howard serves as a lead actor, along with Taraji Henson, who's a Bison Howard graduate, by the way. And two of them are the parents of three boys, and they're leading this quote-unquote empire, and they kind of have this Jay-Z, Beyonce style of growing record label. Go to the next slide, please. And so in the court's decision, there we go. Yeah, that's there you go. So in that decision, the summary judgment ruling in the Central District of California Federal Court, judge said Empire is clearly relevant to Fox's work because the Empire series tells the story of characters struggling for literal control over an entertainment company called Empire Enterprises, and figurative control over the vast quote-unquote empire that Terrence Howard's character, Lucius Lyon, in which he plays, has built. Additionally, the Empire series is set in New York, the Empire State. Indeed, Empire Distribution conceded that the word empire had artistic relevancy to Fox's work. So that first prong of the Rogers test is looking at, how are you using, what is your use of the phrase or the mark that's been accused of in terms of infringement? Is it being used in an artistic expression or in an artistic way? If so, then we're shifting gears and applying this Rogers test. And then the second part is whether or not, as the accused, you've made any explicit or indication or reference to the claimant's trademark or the claimant's ownership of the trademark and their use. And here, obviously, the court concluded that Fox is not explicitly misled consumers about its affiliation with Empire Distribution. In other words, Fox's Empire, they haven't had any guests from Empire Distribution record label on their show. They're not making any reference to the actual record distribution label and so forth. Next slide, please. So the lawyers at Troutman Sanders, who was representing Empire Distribution, obviously did not like that summary judgment ruling, and so they filed an appeal with the Ninth Circuit. And just literally a few months ago, the Ninth Circuit affirmed the summary judgment ruling of the district court, just simply reaffirming the Rogers test, reaffirming that you can't have artistic relevancy to use of someone else who, indeed, in their context, it might be trademark use, but in the context of TV and film, in this entertainment industry, obviously, you have this Rogers test, which does not actually take into consideration the likelihood of confusion factors. It bypasses them. And that was one of the complaints made by Empire Distribution, the record label, was that, well, wait a minute, even if you have this Rogers test, which we don't deny, it does exist, you can't apply it here. We're talking about a movie and movies and music, or excuse me, a TV show and music. But the Second Circuit and the Ninth Circuit there's kind of a split, but at least the Second Circuit and the Ninth Circuit have said the Rogers test is still a separate and independent application, and it can absolve or survive a likelihood of confusion analysis. So you do not have to go through the Sleep-Craft or the DuPont factors. Yeah, there might exist some likelihood of confusion, but we must still take into account the First Amendment and individual or company's rights to be able to kind of push and promote the artistic expression and artistic relevancy and artistic value of their art. So it's a yin and yang scenario, and one that I think will continue to be at issue going forward in other cases. So that's just one case that I thought would be somewhat of interest. So Benita, at Urban One, I think this is good news for you, right? I mean, now it seems like if TV One has a show, come up with a name, you did your search in PTO, didn't find anything, you can now cite to the Ninth Circuit's Fox case, I think, to help support you. So this is a win-win, slam dunk decision if you're on the side of the producer of a show and dealing with talent on the production or distribution side. Not necessarily a win if you're on the artist side. So I think that argument about, well, there's still likelihood of confusion, and I think another thing to do is obviously secure your trademark rights. The judges are just not giving as much deference for common law trademark rights, even though you can assert that under Section 43A Lanham Act claim. They just don't have the time. They are busy. They are some of them are not necessarily IP practitioners by nature. They didn't go into the bench as having practiced IP. They're looking at kind of majority rule, what the majority of cases do, what a majority of parties do, what a council do, and so they're looking for federal trademark registration. So see what this case is about. And so with Empire Distribution record label, which still exists, and they're doing very well. With it's a reputable record label in California, but they did not have a trademark registration, and that served to hinder them in some regard. Next case. All right, so this is a case that's currently pending. I see that this is being recorded, so I'm going to have to be very careful about what I say. It's not over yet, although it will be at some point by the end of this year. But I will just talk very generally about what is public, and then we'll open it up the floor for a quick Q&A session. I'm sure many of y'all will have questions for Ms. Collier here. And so Curtis Jackson, aka 50 Cent, is or has been a well-known hip-hop artist, now turned actor. You can see him on Starz' Power series. It has been no secret if you were to do a Google search for 50 Cent and my client, my firm client, one of my partners, LaRon Rogers in Atlanta, who handles a large number of matters for him. I've been privileged to work on this case because I think we're right. It's always nice to work on cases for clients when you think the facts are in your favor and when you think you're right. Much harder when the facts are not falling in line with the law. So they have beef, let's say. That's what the hip-hop industry or culture would say, beef. And so William Roberts, a.k.a. Rick Ross, lives in Atlanta. He was sued by 50 Cent for having remixed In Da Club. In Da Club, obviously 2002 time frame, very popular song, one of the top 100 hits on billboards of the early 2000s. And Rick Ross did a remix on a mixtape album. There were 26 songs. all from very popular, well-known, respected artists, including Adele. So he remixed Adele's Hello. And so all 26 songs, he's basically using the master sound recording of that song and then throwing or adding his own lyrics. He's not making explicit reference for the most part to any of the original content of the musical composition, but he is making reference, obviously, and just rapping over a pre-existing master recording, or the sound recording, if you will. And so I won't play it because, and I won't play either version because there is some laced profanity well, but I guess under the Slants case and what you all were talking about earlier, Tony, it's okay. It's okay. We're good. We're good. But long story short, that's what is that issue from our perspective is basically the last 19 seconds of a 3-minute and 26-second song, in which the hook, "You can find me in the club, bottle full of bub, mama, got what you need," whatever. So the last 19, 20 seconds, 50 Cent's voice is heard on the remix. Now the beginning of the remix, interesting, Rick Ross has Dr. Dre's own voice on the recording itself. So Dr. Dre is making an introduction, and then Rick Ross starts rapping. And so it's basically an issue about use of his voice on the last 19 seconds of this song, and also the fact that in the this was released for free on the internet, so there's no artwork, there's no cover album. This was not a commercially released album. It's just a mixtape. That's what artists have done, including the king of mixtapes himself, 50 Cent. And he's acknowledged this, took his deposition 2 months ago or a month and a half ago. Very nice guy. And so there's no question that it was a remix or a mixtape, and he's done plenty of them, including having remixed Michael Jackson songs, among others. And it's just something that has always been done in the hip-hop industry. And Rick Ross, and he said this publicly, I do these remixes for the culture. A lot of times these are popular songs, and you just want to hear a different take from a different artist. And so you're just releasing it, you're playing it at the club mainly. You're not necessarily releasing it on an album that is, for profit or in a commercially released context. And so, obviously, we have several defenses here because 50 Cent, and I'm not sharing anything that's private again, this is public. 50 Cent does not own the masters of the musical composition to In the Club. It is owned by Shady Aftermath Records, the imprints for Eminem and Dr. Dre, which are or have been underneath Interscope. So the actual song itself is owned by a non-party, a third party. They're not in this case. The only parties in this case are 50 Cent and Rick Ross. So, and you can fast forward. So the question becomes, can one try to have a right of publicity claim involving a remix of a song when they themselves don't own the rights, the copyrights or ownership rights, and into that song? So if you wanted to do this the quote-unquote right way, or the way in which you're actually getting permission from the owner, my client is not going to 50 Cent. He is going to Shady Aftermath or Interscope Records. So how can you sue somebody, make claim to something that you actually do not own? Yes, you may own your voice separately and independently in a different context, but you were not, you are work for hire under contract, And as an artist, you had no separate or independent right of that voice on that specific recording. And that's the only song we're talking about. That's the only song at issue in this case that's been going on forever, because the judge is just excited and entertained and just wants to hear what is it? This is in Connecticut. And so yeah, I guess if you follow the traditional elements of right of publicity claim, did we use his use? No, we still don't think we did, but it's his voice at the very end of the remix. Sure. Cases generally, outside of music, outside of this factual content, they have recognized voice as an identity element under a right of publicity claim. But that use has to be for advertising purposes or for the purposes of trade. That's kind of the more statutory definition of New York that Connecticut has adopted without consent. Obviously, 50 Cent didn't consent. But at issue, obviously, is going to be this commercial misappropriation element. And it's our view that there was no commercial misappropriation of his use in the context as to how we used it. We had 26 different artists, the other 25 of whom did not have any issue at all with what Rick Ross did. And so, you know, and we're also talking about a factual context of something in which was released for free on the internet. And if anybody was promoting anything, it was Rick Ross, the artist himself. He wasn't using 50 Cent in any way to help him promote himself. He had just come from a party in which he had seen Dr. Dre, and they had been talking, and he was able, through his sound engineer, I think, to get the Dr. Dre's own voice, which is what the engineer had placed on the remix sample itself. So a lot of problems there, we think, on their end, because copyright law, as well as right of publicity law, they recognize this preemption defense. You cannot actually sue under a right of publicity claim if the work at issue is owned by somebody else via copyright. That is the whole essence of the preemption defense. And I've got him on tape acknowledging under oath that he had no separate, and still to this day, has no separate and independent right to his voice as used on that recording of In the Club. And there is no separate permission given to him or asked of him just for his voice, and he's not, making royalties from that song separate and independently from his voice. That is going to the record label, and then he will get his cut, obviously. But needless to say, I think this is an easy case, and on summary judgment, when we file here in a couple of months, I should have good news to report next year. Fast forward to the next slide, please. This is basically just a list of a couple of cases that involve the use of one's voice in a right of publicity context of a copyrighted song. And specifically, I'd point out this Lindsay Lohan versus Perez case, because Lindsay Lohan, a celebrity actress, she had sued Neo, Pitbull, and Usher, their record label, for, I think it was Pitbull, who had actually mentioned her name in the lyrics of one of the songs on the album, and she didn't like what he had to say, so she sued him for a right of publicity violation, and New York dismissed the case on preemption grounds. Similarly, I don't know if you all are fans of Beyonce. We remember Drunk in Love, popular song to some. So at the beginning of that song, you hear a distinctive voice that is not Beyonce. It lasts for about 10 seconds. It's the interlude into the playing of the song. That is from, I believe it's a Hungarian singer that actually does exist. She exists. And so she sued Beyonce for a right of publicity violation because, hey, you didn't get permission to use my voice in that clip and that beginning intro of the Drunken Love song. So, and the court actually dismissed it at the early 12b6 stage, just under the First Amendment defense, saying that that Beyonce is an independent artist in her own right, and that it's artistic expression. They cited to several music cases in which they talk about how in music, under the First Amendment, one has a right to express themselves. So they did kind of a Rogers test application, or copyright fair use defense, if you will, in the right of publicity context, acknowledging that Beyonce basically, as an artist, had an artistic expression way of how she performed on the song, and thus was protected under the First Amendment. And then they also adopted the de minimis use to First Amendment defense. You know, we get trained to say, don't sample, get a license. And that works for many of us. But there are cases, as late as this one, that is still taking the de minimis use approach, and her voice was used at the very beginning. You're not going to hear that voice again throughout the rest of the song if you listen to it. So now everybody's going to go home and listen to Drunken Love. But so under the de minimis use doctrine, as well as the as well as the artistic expression concept, both of which are statutorily recognized in New York by New York's right of publicity statute, they found in favor of Ms. Knowles. And then I think Lita had mentioned this case earlier. I don't know if she did it today or not, but Drake, he was sued, had used or incorporated lyrics of I think it was a jazz artist, and they found in his favor, or his record label's favor, as under the First Amendment defense, acknowledging that it was intended transformative use. That his own use of the lines were intended transformative use. So we're going to give the judge a lot of outs to have this case resolved on summary judgment, either under preemption doctrine or under the First Amendment as artistic expression and de minimis use. And if he denies it, we will just file an appeal. These are easy facts, but you just never know how a jury might see it. They may not quite get the preemption doctrine, all these legal principles. They're just going to hear his voice at the end of a remix, and that might be enough for some. So not going to take any chances. We'll file an appeal if we lose, but I don't think it'll come to that. All right. So with that, do we have any questions for the floor before MTEMA dismisses us? Any questions for Ms. Collier?
If anyone has a question before we go to the next panel. I just wanted to know, what do you say about, I was kind of thinking about this because I'm in copyright the course now. I was kind of thinking a lot of artists now use what seems like voicemails or recorded messages on their phones from other people. And I was wondering how that would play out in court. If someone was to sue someone who had used their voice from a voicemail that they had, I guess, sent on that person's phone or left on that person's phone, how do you think that would go in court with respect to copyright?
I think it depends on the use. For Connecticut, New York, largely Second Circuit, it's not just that you use somebody's identity, but that you used it in a commercial context for advertising purposes or purposes of trade, to be more specific. So it would depend on how that recorded voicemail is being used. And then some courts go even further and say, well, if you're just, average John Doe off the street, you may not be as perceived or entitled to this presumption that it's some persona right that's been misappropriated. They like to see that you as an artist too, or you as whatever it is that you're complaining of, that you've also actually taken advantage and you actually kind of have your own lane in which you have a presumption that this is your use and this is what's required in order to use it. So in the 50 Cent Ross case, they produce all of these endorsement deals that 50 Cent has done, mainly in TV. And I'm like, okay, great. That has nothing at all to do with this case. But they're doing that because they want to show that, hey, this guy's a celebrity, you've exploited his use, it's a distraction, it's a smokescreen, but that's because some of the law kind of speaks to, well, how exactly do you use what you're complaining of? So that's my answer there.
All right, thank you so much.